Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law. So, today I am going to discuss police atrocities as a big threat for human rights. How police atrocities are considered as a big threat for the protection of human rights. Friends, in this lecture I would like to highlight those areas where police they commit violence, either custodial violence, custodial death, or many times they deviate from their statutory behaviors. Though there are statutory requirement that police officers, while investigating the case, interrogating the case, will have to follow certain procedures. But in spite of that, statutory warnings, statutory safeguards, constitutional safeguards, it has been seen that custodial violence, custodial death, torture, unwanted arrest, illegal arrest comes into picture, or many times humanitarian organization, Human Rights Commission has to take action against those police officers who are involved in police atrocities. So, though police atrocities it appear into different form like custodial torture, custodial death, custodial rape, assault, illegal arrest, wrongful confinement. So, these are the words which are used for custodial violence or police atrocities. So, and custodial death and custodial violence are most heinous act which are committed by delinquent police officers in the name of interrogation. Many police officers, they have contributed, they have rendered their services, they have contributed a lot in interrogating, investigating the case, but on the other hand, police officers, few police officers who are also involved in police atrocities. So, Supreme Court itself has taken care of, has given warning to the police officers who were delinquent, who did not perform their duties prescribed by the statute. So, I would like to highlight those statutory provisions which specifically talks about that how arrest would be made, under what circumstances a person can be arrested without warrant, and under what circumstances a person cannot be arrested without warrant, without order of the court. So, you all might be knowing that depending on the nature of the crime, depending on the basis of nature of crime, offences are classified into two categories: cognizable offences, non-cognizable offence. Cognizable offences are more serious crime, those serious crime which have been declared as cognizable in first schedule of the CRPC 1973, wherein police officers have power to arrest the person without order of the court. Second type of offence is non-cognizable offence. In non-cognizable offence, police officer cannot arrest any person against whom allegation, against whom complaint is made. So, without order of the court, no person can be arrested by the police if offences comes within ambit of non-serious crime, non-cognizable offence. After having order from the court, police officer can arrest. So, who can be arrested and who cannot be arrested, this thing is specifically provided in the statute. In spite of that, it has been seen that police officials, many police officials, they are involved in police atrocities, they are involved in custodial violence. So, I would like to cover even that aspect in this lecture, but first of all I would like to highlight that statutory provision which gives liberty to the police officer to arrest any person without warrant. Section 41 of the CRPC is very important, which I would like to refer. According to section 41 of the CRPC, a person can be arrested by the police officer without warrant if he has committed any cognizable offence or he has been associated with cognizable offence. So, there are several conditions on which anyone can be arrested by the police if matter comes within ambit of section 41 of the CRPC. No doubt, if you all might be aware about section 41. In addition to this provision, how arrest would be made, not only circumstances have been identified in that statute, but even manner of arrest has also been prescribed in the statute, that in what manner police officers shall arrest. So, manner is also specified in that statute. Section 46 of the CRPC talks about how to arrest. Section 41 when talks about when a person can be arrested, and section 46 CRPC talks about how a person can be arrested, how arrest shall be made. So, how arrest shall be made talks about manner of arrest. So, manner of arrest is specifically guided and controlled by section 46 of the CRPC. If police officer, arresting officer has not followed the procedure prescribed in section 46 of the CRPC for arrest, then it would be violation of that statutory provision, and the legality of the procedure which police officer, arresting officer has adopted at the time of arrest may also be challenged and may also be inquired by the court. If it is found by the court that procedure was not followed by the arresting officer, then court may take action against the police officer. So, obviously, when this law was being enacted in 1973, lawmakers, they were very much aware about the things which police officer they can do or they have been doing in this country. So, in order to keep them in legal bound, in legal framework, so that they cannot violate their limit fixed by the statute. So, that is why that Criminal Procedure Code 1973 has specifically prescribed those boundaries, those limits under which police officer, arresting officer has to arrest, and circumstances under which police officer are bound to arrest. So, with the help of these two provisions, section 41 and 46, we can understand that in order to prevent police atrocity, in order to protect the rights of innocent person, in order to prevent police atrocities, these two important provisions have been inserted in the CRPC. When arrest shall be made and how arrest shall be made, these two important provisions. You all might be aware about Bhagalpur blinded case, Khatri vs. State of Bihar, AIR 1980 Supreme Court. That case is popularly known as Bhagalpur blinded prisoner case. So, in my previous lecture, I have already highlighted the facts of this case. So, but quickly I would like to highlight the fact of this case, what happened, what actually happened in Khatri case. In Khatri vs. State of Bihar case, many police officers, investigating officers who had committed police atrocities, means they had blinded prisoners by taking their eyes, by pouring acid in their eyes. So, due to which accused they lost their eyes, and when matter was referred to the Supreme Court, when that matter was brought into the notice of Supreme Court took cognizance of that, and Supreme Court directed the state government to provide compensation. And you see in that Khatri case, all the victim of crime, they were shifted from Bihar to Delhi, and in Delhi Supreme Court issued direction to the state government to shift all those victim of crime to Delhi, so that their treatment, their proper treatment can easily be ensured, can be effected in that state in Delhi. As a result of that, Supreme Court directed the state government to provide compensation in that case. Khatri case is first important case where Supreme Court issued direction to the government, and High Court was also directed by the Supreme Court to take action against that judicial magistrate who had given remand to those victim of crime who had lost their eyes. So, when Supreme Court asked the state government then that why did state government did not provide legal aid free of cost, because all those victims who had lost their eyes were poor. So, they were poor, they were not in position to engage their counsel. So, why did not judicial magistrate provide free of legal aid free of cost? So, you will be surprised to know the plea which was taken by government before Supreme Court, that they did not ask, means victim of crime, they did not ask for legal aid before the judicial magistrate. So, Supreme Court said no, this plea can be accepted, because victim of crime, they were poor as well as they were ignorant about their rights, they were not literate person, they were not aware about their rights. So, it was the duty of judicial magistrate to provide advocate, to provide counsel free of cost, though it was not demanded, though it was not requested on behalf of the victim. So, Supreme Court did not accept. So, you see how Supreme Court took cognizance of this case, and in this case compensation was also awarded to the victim of crime. Second important case on police atrocities, that is Nilavati Behra vs State of Odisha, AIR 1993 Supreme Court. This is a leading case on custodial death. What happened in that case? Nilavati Behra vs State of Odisha, AIR 1993 Supreme Court. You see, you will be surprised to know, after having after knowing the facts of this case, where in this case what happened, a 20-year-old boy was called by police to give reply. He was a suspect, a 22-year-old boy was a suspect in a case. When that boy went to the police station, he was interrogated. After interrogation, the dead body of that boy, 20-year-old boy, was found nearby the railway track. Postmortem, that body was, when postmortem was conducted, report was prepared by practitioner, by doctor. In that postmortem report, he highlighted that, doctor stated that the cause of death was internal injury, grievous injury was found in the body of the deceased. This kind of observation was made by postmortem, by doctor in postmortem report. In this Nilavati Behra, when she inquired about her son, police officials, they did not give reply. Then she wrote a letter to a judge of the Supreme Court. Her letter was accepted as a letter petition. Supreme Court, by accepting her letter as a letter petition, directed the High Court of that state, Odisha, And when allegations, when Supreme Court found the allegations are true, which Nilavati Behra had stated in her letter, Supreme Court, considering the postmortem report and allegation made by the mother of deceased, directed the state government to provide 1,50,000 compensation to Nilavati Behra, mother of deceased. So, you see how police atrocity or police custodial death, this kind of thing happened in that state. A matter was referred to the Supreme Court. Supreme Court took cognizance of that case, and ultimately those police officials who were involved in that incident were prosecuted and convicted. This is another remedy in this case. One is criminal and another is civil. Compensation was awarded to the victim of crime, and police officers who were involved in that custodial death were also prosecuted and convicted. Now, come to another this aspect of custodial torture. Protection against custodial torture, that is provided under Article 5 of UDHR, that is a human right according to Universal Declaration of Human Rights. According to Article 5 of UDHR 1948, protection against torture and inhuman treatment, that is human right of every person and every human being. Authority should not misbehave, or authority should not commit any kind of unwanted torture against the offender, against the accused. Otherwise, it would be violation of human right provided in UDHR. Khatri vs. State of Bihar, this is another important case which I have already highlighted, police atrocities. Supreme Court also held that it is violation of Article 21 of the Indian Constitution. Custodial, there are two important case laws on custodial death. Nilavati Behra, you look at your screen, you will find that Nilavati Behra and State of Odisha AIR 1993, and second important case on this is Saheli vs. Commissioner of Police, Delhi. This is case on custodial death. Compensation is not important, may be adequate or inadequate. I am not going into the technicality of amount of compensation. The important thing is that, significant thing is that Supreme Court for the first time not only held responsible, not only held state government responsible for the wrongs committed by its representative, but also awarded compensation to the victim of crime. So, recognition of compensatory jurisprudence is important, recognition of right is important rather than amount of compensation. Amount of compensation may be inadequate, but recognition of right is more significant, more important. So, Supreme Court accepted this case as a case of custodial death, that is more important than awarding compensation to the victim of crime. So, this thing you all need to understand, and when custodial death will be brought into the notice of Supreme Court, Supreme Court will take action against those officers who are involved in such kind of incident. Neither they can be suspended or terminated, they can also be prosecuted and convicted for committing custodial death. It would be, that case would be considered under section 304, culpable homicide not amounting to murder. They have breached the law, they have committed murder. So, they can also be, police officer can also be prosecuted and convicted for committing murder, fake encounter. So, custodial death is a very serious concern, and Supreme Court has always been very much concerned on these two important issues, custodial violence and custodial death. So, now come to another slide, this you just look at on your screen. I have highlighted three important case laws: PUDR vs. State of Bihar, AIR 1987, People's Union for Democratic Countries, State of Bihar, Rudal Shah vs. State of Bihar, AIR 1982, Bhim Singh versus State of Jammu and Kashmir. What happened in this? You see, this case is important in protection of human rights, and this case is also important on police atrocity. How police committed atrocities, how police committed violence against the victim. So, in PU you see how I will discuss one by one. You see how what actually happened in PUDR case, People's Union for Democratic Right. This is an NGO, People's Union for Democratic Right. In PUDR versus State of Bihar, what happened? When 600 to 700, about 6 to 700 poor farmers, they were demanding their legal demand from the government, and they were demanding their certain rights from the government peacefully, and peaceful demonstration agitation was going on in Patna. But police officers who were present at the place of occurrence, without any prior information, they superior police officer, they ordered to fire on that mob, peaceful mob, that those farmers, poor farmers, including women and children, they were sitting in a ground in Patna, and they were demanding their rights from the government. In that incident, as per the direction of superior police officer, when he ordered for firing, about many, means even children, women and children, they lost their lives, were killed by police. Since they were poor, they were not in position to bring their case before the court on account of social constraint. Even they were poor and they were also illiterate. They did not have any idea about such kind of provision, legal provision. So, it was decided by PUDR to fight their case on behalf of the victims of crime. PUDR decided to fight their case, and when matter was brought into the notice of Supreme Court issued the direction against the government of Bihar, and Bihar government was directed by Supreme Court to provide compensation to each and every deceased who had lost their lives in that incident. So, death, in case of death, compensation was awarded, and those farmers who were became handicapped or who were partially injured, they also got some compensation from the government. So, Supreme Court held the government responsible for the incident which took place in in this case, and Supreme Court said that since police officers, they were acting on behalf of the government. So, government, it is the state liability, and government should be held responsible for the act, for the wrongs committed by its representative, committed by the police officers. So, Supreme Court did not accept the plea of sovereign immunity. Supreme Court did not accept the plea which state government had taken before Supreme Court, that police officers, they were performing their duty. So, they should be exempted, leniency should be given to the lenient approach should be adopted against the police officer, because they were bound to perform their duties. Supreme Court did not accept. Supreme Court said that they breached their limit, they must be punished for the act which they had committed. So, this is another important case where not only compensation was awarded, but police officers were also prosecuted and convicted for killing of poor farmers. Second important case on this point is Rudal Shah versus State of Bihar. You see, you look at your screen, Rudal Shah, this case is on illegal detention, and even in this case, in Rudal Shah case, as I said, Rudal Shah, was to be released in 1968. In 1968 he was to be released, but he was released in 1982. So, he had to live in jail more than 14 years. Why? When this matter was brought into the notice of Supreme Court, that due to negligence of superintendent jail, that accused had to remain in jail, had to spend his very precious time in jail. So, jail authorities, they took plea before the court that they did not receive the order of the judgment, whether he was acquitted or not. Jail superintendent jail had no idea about that order. So, this kind of plea was taken, and ultimately Supreme Court fixed the accountability of police officers, and government were directed to provide compensation to the victim Rudal Shah. Rudal Shah was provided compensation by the government. At the same time, government was also directed to take action against those officers who were involved in that incident. This is another important case on custodial violence, police atrocities, Bhim Singh versus State of Jammu and Kashmir, that is a important leading case on unlawful arrest, illegal detention. So, quickly I would like to highlight the facts of this case, Bhim Singh versus State of Jammu and Kashmir. What actually happened in this case? Bhim Singh, being a member of Legislative Assembly, was going to participate in proceeding of the house, but he was arrested. Though he did not lose, though his absence in the house did not make that proceeding illegal or did not affect the proceeding of the house, but he was arrested. When he was arrested by the police and he could not participate in the assembly session, when he challenged the legality of his arrest before the court, government took plea before the court that his arrest was lawful and police officer had power to arrest him, and his arrest did not affect the proceeding of the house. So, what is wrong if he was arrested? Supreme Court held responsible to the police officer who had arrested him, and state government were directed to give compensation for illegal detention. Detention was declared illegal, unlawful, and Supreme Court said that protection against illegal detention is a fundamental right. No one can be detained by police officer without sufficient cause, without sufficient reason. If police officer has arrested somebody without sufficient reason, without cogent reason, then arrest would be unlawful as well as unconstitutional, and police officer shall also be held responsible for unlawful arrest, and government concerned will have to provide compensation to the victim. State is free to take action against the police officer who has arrested person wrongfully, but at the same time state will have to pay compensation to the victim of crime, to that person who is wrongfully arrested by the representative, by the police officer, because they are working on behalf of the government. So, that is why government is responsible for all the bad deeds of the police officers who are working on behalf of the government. So, these are three important case laws on police atrocities. Now, come to another aspect. You see, you look at your screen, I have referred the specific word role of Supreme Court in prevention of police atrocities. So, now in this slide I have highlighted three important judicial pronouncement, wherein Supreme Court has issued various guidelines for prevention of police atrocities. How police atrocities can be checked, can be controlled. The first case is, you see, D.K. Basu versus State of West Bengal, AIR 1997 Supreme Court. In this case, guidelines are very important. These guidelines are for the protection of rights of innocent person. These guidelines are important for prevention of police atrocities. First guideline is very important. You see, in this case, Supreme Court said that whenever a person is arrested by the police, soon after his arrest, information regarding arrest must be given to the relatives of the arrested person or any friend of the arrested person. So, relatives, in case of non-availability of relatives, friends of the arrested person must be communicated, so that police atrocity, so that police cannot commit any kind of custodial violence against the arrested person. This is the logic, this is the rationale behind giving direction by Honorable Supreme Court. If information regarding arrest would be given to the relatives or friends of the arrested person, then they will be active. Relatives or friends will be active. They will approach the court, they will knock the door of the court, and when court will interfere, then police, there would be little chance, there will be little probability for police atrocity or custodial violence. This is one important aspect of giving information about arrest. Second important guideline is ground of arrest. Every arrested officer is under obligation to give ground of arrest, to communicate ground of arrest to the arrested person. Arrested person has right to know the ground of arrest, on what ground he has been arrested by the police officer. Every arrested person has right to know. The third important guideline is, you see, preparation of arrest memo and recovery memo. Arresting officer will have to prepare arrest memo. In that arrest memo, the time and place of arrest, by whom person was arrested, what was the name of arresting officer, rank of arresting officer, time and date of arrest, and most importantly, the signature of two local resident is also necessary in that arrest memo, so that they may be called, that local resident may be called before the court to verify that person was arrested in the presence of two local resident. So, their signature is also necessary. So, this arrest memo must be prepared, so that on the basis of arrest memo, court may inquire that whether constitutional mandate was observed by the police officer or not. What is constitutional mandate? That every arrested person must be produced within 24 hours from the time of arrest. If time and place is specifically mentioned in memo, in arrest memo, then it would be very easy for the court to verify the time of arrest and the time when accused is produced before the court. Is there any difference, or whether the accused has been produced before the court beyond 24 hours or within 24 hours. So, court will examine, court may verify with the help of arrest memo. So, arrest memo, now arrest memo is necessary part of arrest. Another important guideline of this case is D.K. Basu case is preparation of recovery memo. Whatever weapons, whatever materials are recovered from the scene of crime, all the relevant materials, relevant evidence, all the relevant informations gathered from the scene of crime must be duly signed by two local residents, and recovery memo, whatever material, weapons, arms and weapons are recovered by police from the scene of crime must be forwarded to the magistrate within whose local jurisdiction offence was committed, crime was committed. So, recovery memo is very important, arrest memo, recovery memo. So, recovery memo must be prepared by investigating officer. So, these guidelines, these are few important guidelines of DK Basu case. If these guidelines are followed by police officer, investigating officer, there would be very less chance, less possibility for police atrocities. So, this Supreme Court has issued these guidelines for prevention of police atrocity. Second important case on this point is Joginder Kumar vs. State of UP, AIR 1994 Supreme Court. This is also leading case on this point, where Supreme Court said that every arrested person has right to know the ground of arrest. In this case, Joginder Kumar case, arrested person must be provided counsel soon after the arrest. So, this is another one important guideline of DK Basu case is every arrested person has right to have counsel at the time of interrogation, at the time of investigation. Arrested person can take assistance from his counsel, what to speak, what not to speak. So, advocate would be the right person. So, presence of advocate at the time of investigation would be a guarantee in eye of Supreme Court, would be a guarantee for what? Not to violate any right of the arrested person, because if advocate is present at the time of investigation, that advocate would be for the benefit of arrested person, and advocate, presence of advocate will avoid any kind of unwanted situation, unwanted happening which might happen in the absence of advocate against the arrested person. So, Supreme Court has also emphasized that arrested person has right to have counsel. He may also take assistance from his advocate at the time of investigation when he is in custody. So, this you see this kind of protection, this kind of guideline which Supreme Court has given in this case, that is very much helpful, and it has, you see, these guidelines have played important role, vital role in prevention of police atrocities, because can you imagine if these guidelines would not have been recognized by Supreme Court. Before you see, these guidelines came into force in 1997. Before 90, you can realize, you can imagine the situation of police atrocities before passing these guidelines. In before 1997, what would have been the situation of police atrocities, or so meaning to say that these guidelines are very important, and these guidelines have been very effective in protection of rights of arrested person. So, arrested person they can use these guidelines as a shield. These guidelines are like a shield, protective umbrella which they can use. Now, these are two important case laws, DK Basu, Joginder Kumar vs. State of UP, IIR 1994. Third important case law, that is the Delhi Judicial Service Association 30 Hazari vs. 30 Hazari case, AIR 1991 Supreme Court. Guidelines regarding arrest of judicial officers are very important. That is very important case on this. Delhi, you all might be aware about this case, Delhi Judicial Service Association 30 Hazari case. What happened in this case? You will be surprised to know when a chief judicial magistrate was arrested by the police, and police officer had arrested a chief judicial magistrate, and that chief judicial magistrate was handcuffed. That arrest, that news got attracted the attention of print or electronic media. Matter was highlighted, was brought into the notice of Supreme Court that a chief judicial officer was arrested by the police. Judicial officer was wrongfully arrested by the police. Action. So, Supreme Court took cognizance and Supreme Court issued guidelines that these are the guidelines for protection of the judicial officer. No judicial officer shall be arrested without prior permission of the High Court or district authority. So, prior permission is necessary. No, so you see how means even police officer can take such kind of step where police officer can arrest a judicial officer also. So, this is another aspect of police atrocity where judicial officers are not safe. Even in this case, what actually happened. Now, come to statutory provision and the significant area, statutory provision for prevention of police atrocities. So, with the help of statutory provisions, I would like to highlight those relevant statutory provisions which have been specifically provided in the statute in order to protect police atrocities. The logic behind incorporating these provisions in the statute is to prevent police atrocities. How these provisions are helpful? You might be aware about section, you look at screen, section I have referred section 24, 25, 26 Indian Evidence Act 1872. Confession made to police is not relevant. Section 162 CRPC, section 50 CRPC, article 22 of the Constitution, production of accused within 24 hours to nearest magistrate. You all are aware about this constitutional provision, and you see with the help of this arrow, what is the purpose of these provisions? Purpose to prevent police atrocity, custodial violence. How section 24 and 25 Indian Evidence Act is helpful in preventing police atrocities? Section 24 Indian Evidence Act says that confession made to the police officer is irrelevant. The statute law is that whatever confession is made by an accused to the police officer would not be considered as a piece of evidence. So, according to section 24 of the Indian Evidence Act, admission of guilt by an accused to the police officer would be irrelevant, would not be considered as a piece of evidence. So, logic behind not accepting confessional statement is that presence of police may create fear in the mind of statement maker. The presence of accused, the presence of police before accused may create fear in the mind of accused, and due to that apprehension, due to the apprehension of threat or fear, accused may accept his guilt. Though accused has committed no crime, accused is innocent, but due to threat or due to fear, due to that fear, if accused will not confess, will not accept his guilt, police will torture, police will use third degree method. So, in that apprehension, any innocent person may accept his guilt before the police officer. So, that statement will not be considered as a piece of evidence before the court. So, this is the logic. So, that statement, the reason behind not accepting that statement as a evidence, as a piece of evidence, is that threat or fear in the mind of accused might be, it is quite possible that any innocent person, due to fear of punishment, due to fear of threat, may accept his guilt, and that is why section 24 does not accept any kind of confessional statement as a piece of evidence. Another important provision, section 25 of the Indian Evidence Act clearly says that whatever statement is made by an accused in police custody, earlier I said statement confession to the police officer, section 25, section 26 confession made in police custody is irrelevant. Section 24 says that any kind of threat inducement which is given by investigating officer, by police officer to an accused, and statement is obtained by investigating officer under compulsion, under threat, that statement would be irrelevant, will have no value. So, confessional statement obtained under threat or inducement would be irrelevant, would not be considered as a piece of evidence under section 24 of the Indian Evidence Act. Section 25 says that confessional statement made to the police would be irrelevant. Section 26 says that confession made by any accused in police custody would be irrelevant. There are three important provisions, section 24, 25, section 26 of the Indian Evidence Act. So, you will have to consider all these three provisions, and after considering the logic rationale behind not accepting any statement which is given to the police or in police custody as a piece of evidence is threat, inducement, fear. So, that is why confessional statement, any statement which is given to the police or in police custody has no value in eye of law. So, these statutory provisions are very much helpful in prevention of police atrocities. Another important statute is CRPC, section 160 CRPC, section 50 CRPC. Section 162 CRPC says that statement made to the police officer should not be signed. Whatever statement is made by a person at the time of investigation should not be signed. Any person may refuse to give his signature at the time of investigation. Section 50 CRPC says that every person has a right to know the ground of arrest. On what ground police officer is going to arrest. So, ground must be communicated to the person. So, without informing the ground of arrest, no police officer can arrest any person. So, this you see, this kind of protection, this kind of statutory provisions are provided in the statute, and the sole purpose of these provisions is to prevent police atrocity. Article 22 of the Indian Constitution, a person has fundamental right to be produced within 24 hours. A person has fundamental right to know the ground of arrest under Article 22. A person has fundamental right to have counsel of his own choice, to get legal assistance of his own choice, Article 22 of the Indian Constitution, so that police officer cannot violate his fundamental right. If counsel advocate would be present at the time of investigation, police officer will not commit any kind of violence, because police officer, they are very much aware about the presence of advocate, because advocate may use their statement or their method as defense, to defend his client, the accused. So, these are statutory safeguards as well as constitutional safeguards provided in the statute and the Constitution. The purpose behind these statutory provision and constitutional provision is to prevent police atrocities. So, now come to another aspect of protection of human rights, how human rights can be protected. With the help of this slide, I would like to highlight two important judicial pronouncements. The first is Prem Shankar versus Delhi Administration AIR 1980 Supreme Court. Prem Shankar case, protection against handcuffing. You see, this is a human right provided in Article 5 UDHR, protection against inhuman treatment, protection against handcuffing. So, protection against handcuffing, Prem Shankar Shukla case, what actually happened in this case? Prem Shankar versus Delhi Administration AIR 1980. In this case, petitioner wrote a letter to a judge of the Supreme Court by highlighting the plight of inmates of the prison, that a prisoner was put on bar fetters, though the nature of crime which he had committed, the offence which he had committed was not so serious. And whenever that accused under trial prisoners was to be produced before the court, he had to face that accused was to be produced before the court in that bar fetters or handcuffing. He was always means in bar fetters. So, this kind of practice was challenged, that the decision of that jail authority was challenged, that whether there is any rule in Jail Manual Prison Act that any prisoner can be put on bar fetters, can be, or handcuffing is necessary. So, Supreme Court in this case held that handcuffing is not necessary unless there is apprehension that accused may abscond from the custody. So, protection against handcuffing was recognized in this case, that no person should be handcuffed, no person should be put on bar fetters unless there is possibility, there is apprehension that he might abscond from the custody. So, Prem Shankar versus Delhi, in this case protection against handcuffing was recognized as a fundamental right under Article 21 of the Indian Constitution, because Supreme Court said that even prisoners are entitled to live with human dignity. They do not lose their precious right merely because they are prisoners, they are under trial prisoners. They can enjoy all the fundamental rights, all the human rights except few freedoms. Kishore Singh versus, you just look at your screen, Kishore Singh versus State of Rajasthan AIR 1981 Supreme Court. In this case, Supreme Court held that third degree use is violation of Article 20, violation of, this is violence incorrect, that is violation of 21. So, third degree use is violation of Article 21, and the last point which I have covered in this police atrocities, Mathura rape case, Tukaram versus State of Maharashtra AIR 1979 Supreme Court. This case is also known as Mathura rape case. Section 114A Indian Evidence Act 1872, this provision was inserted in this Indian Evidence Act only because of this judgment. And in this case what actually happened, this is a case on custodial rape. In this case, dissenting view of Justice Krishna Iyer was very appreciable. In this case, Justice Krishna Iyer gave his dissent opinion that though there was no scratch on her, no scratch was found on her body, on the body of victim of crime, Mathura, who was raped by Tukaram, appellant Tukaram in police lockup, and where the incident took place in police lockup, it would be very difficult for any female, for any victim to raise voice, to make any kind of voice against the police. So, court should not realize, court should not make emphasis that in such a situation voice or objection should be raised, resistance must be must have been there. So, Justice Krishna Iyer observed that even in helpless situation where victim was in police station and the wrongdoer offender was a police constable, in such a situation it would be very difficult to draw a conclusion that that victim should have raised voice against the act. So, that is why this case was very in this case Supreme Court said that this was that rape was consented, that rape, this is not a case of rape, act was done by the Tukaram, by police constable with the help of, with the consent of the victim, because no scratches were found on body of victim. So, we cannot draw inference that it was against the will or consent of the victim of crime. It was a consented act. So, that is why they were acquitted. Appellant Tukaram and his guilty partner were acquitted from the charges of section 375 IPC. But dissenting opinion of Krishna Iyer was very important. In 1981 in Rafiq versus State of UP, Supreme Court reaffirmed, upheld the dissenting opinion of Justice Krishna Iyer and held that in such a situation, in custodial rape, court is bound to presume that there was absence of consent, act was committed by the offender against the consent of the victim of crime. And due to that judicial pronouncement, Parliament had to make slight modification in Indian Evidence Act 1872, and it was inserted, section 114A was inserted in this act with the condition that in rape cases, once it is proved before the court that once objection is raised by the victim of crime, by rape victim, that act was committed against her consent. So, court will presume that, court shall presume that act was against the consent of the victim of crime, and onus lies on the accused to prove that case. Now, onus is on accused. Accused will have to prove that act was committed by act was committed with the consent of that. So, with the help of these case laws, I tried to cover all the statutory provisions and constitutional provisions, role of Supreme Court in order to prevent police atrocities, how police atrocities have always been a great concern of Supreme Court, and Supreme Court has taken tough action, stern action against the police officers who are involved in this kind of practice by issuing various guidelines for the police officers. So, with this I would like to conclude my lecture, and I do believe that you all have understood this lecture, police atrocities as a big threat to human right in that sense in which I have mentioned in this lecture. And I do believe that if you all read all these things, then I think you can qualify any kind of examination, whether it is APU or PCSJ or any kind of examination, because I have covered each and every aspect of police atrocities, statutory provision, constitutional provisions, and role of Supreme Court in prevention of police atrocities. With this, I would like to conclude this lecture. Thank you all.